Good evening. My name is Michael Hunter Schwartz. I'm the 10th Dean of McGeorge, and I welcome you to what is now the 17th event of our 100th anniversary festivities, and our 6th national level speaker as part of the series. I hope you've also been following our efforts to celebrate all the different aspects of our great law school, and particularly lately I found myself enjoying our celebration of 100 alumni, mostly because we've now taken to cheating, meaning that we're announcing alumni in groups, you know, like the 150 trial judge alumni as a big group. So, or the, 13 elected district attorneys. That's how you get everybody, and you hopefully not get anyone too mad at you, and you also get to keep yourself within the 100 that you promised to stay within. And we are officially on 94, and so we're coming to the end as well. We certainly have saved one of our very best speakers for tonight. In a moment, I'll let Professor Vitello introduce her. And this is another one of the two speakers that Professor Vitello basically made it clear to me that if I wanted to continue to exist in the world, that I would have to let him do the introduction. And so I took that advice because I enjoy being alive, and so I'm going to let him do the introduction. I do want to let those of you who will be there know how excited I am to see you on Saturday night at our 100th anniversary gala. We are looking at about 350 attendees at the gala. It's going to be beautiful and great. So I look forward to seeing those who are able to attend there. And so I'll conclude by introducing my colleague, Mike Vitello. I'm not going to do a big, long bio because it's actually not his shtick, but I do really appreciate, and I haven't really had a chance to publicly thank him and Professor Levine for their efforts in helping to organize our speakers and a lot of our festivities for the 100th anniversary. They put a lot of work into this and a lot of thought into this, and we've been able to have such a spectacular lineup of speakers in large part to their connections and persuasive skills. So please join me in welcoming and thanking Professor Vitello.
I hope that was recorded, Mike. I may need it later. So instead of doing a long description of Professor Gruber's biography, I trust that you can find it on the University of Southern California website. I just want to share 3 thoughts about Aya Gruber, and that really the reasons why I'm so excited about her being here and participating. I met her in 2015. A former colleague, Raquel Aldana, and I organized a symposium for the Law Review on sex offenses, and sex on campuses. My former criminal law professor, Steve Schulhofer, is a reporter for the American Law Institute project, reforming the sex offenses for the Model Penal Code. And I persuaded him to participate in the symposium, and I asked him, look, we need somebody to debate you, and he gave me Aya Gruber's name, and it turned out to be what you really want in an academic debate. It was civil, spirited, and provocative. And they broke stereotypical male-female roles. Steve was pushing to expand the criminal law in ways that Professor Gruber was more hesitant about. And her thoughts, her comments were remarkably thoughtful. The next point I want to make about her is that she is the author of what I think is probably the best book criticizing the victims' rights movement. The feminist war on crime, I think I can say without contradiction, is really the best book criticizing the movement. In fact, my research assistants know about it. There are many copies of the book that I have bought because each time I have a new research assistant, when I'm quoting her book, I'm very often running out and buying a new copy of it. It is just a really excellent read. Indeed, if you have not read it, and if you have a birthday coming up or a holiday celebration, put it on your list of books that you want to read. And I will part, and to leave as much time as possible for her remarks, by telling you that right now in the legal academy, a number of the older guard have retired. They've sent some of them out to pasture. The dean would like probably to see me go out to pasture. But if you look at the bright young scholars who are now in the criminal justice field, Aya Gruber is at the very top of that field. And without more, Aya.
Well, that was nice. Thank you so much. Thank you, Dean. Thank you, Professor Vitello, who I have to say, that symposium he invited me to, I really think it was a very important gathering, and I think it had a profound influence on the current iteration of the Model Penal Code, in my opinion, for the better. So I also thank Monica Lopez, who helped me with the logistics of coming here, and I want to thank you. I know that there are a lot of things you could be doing now, like happy hour, or maybe not so happy being stuck in rush hour traffic. But thanks for coming to hear me out. And I do want to give you a little trigger E warning that this is a talk on sex and sex criminalization. And you know, those are touchy subjects, but one of my main goals is to kind of take them out of the closet, out of the dark, into the light. Because I think that we all want, oh, I thought I turned my phone off. I don't know. I'm so sorry.
No, I think I can turn it off.
Okay. Here, I'll do it. I just did it. And
I was glad it wasn't mine.
yeah, I just did it. And why did it go back on? Okay, mystery phone. All right. So because I think that bringing all of this out of the dark allows us to make better sex criminalization policy, sex regulatory policy, and sex liberatory ideas can come from it. And, you know, personally, I think the state of our criminal law in general, and probably especially in the sex area, the area of sex regulation, is kind of a mess. So I hope you'll take this talk with that spirit in mind. So for modern progressives, sex criminalization is a conundrum. On the one hand, all criminalization necessarily occurs within our racialized policing and prison system, which millions of progressives took to the streets to condemn in 2020. In the current moment, progressives are sounding the alarm at the campaign on the side of the right to regulate away post-sexual revolution liberal culture. And its targeting of groups like LGBT and pregnant mothers once thought too sympathetic to prosecute. Even librarians, right, for showing the wrong books. Let me just move this here. On the other hand, for progressives, punishing male sexual misconduct has resided at the top of the feminist agenda for literally centuries. And it continues to reign supreme, as the Me Too movement showed. The paradoxical result is that anti-racist, gender justice-minded progressives are often the most punitive about sexual misconduct, even minor misconduct. Me Too alone heralded a slew of tough-on-crime policies we are only now beginning to study. The progressive position on sex vacillates between fighting for sexual liberalization in the face of an invigorated moralist repression and fighting against sexual liberalization because sex harms women. My book in progress, The Crime of Sex, situates this conundrum within a larger historical, political, and philosophical story of American sex criminalization to provide guidance to those who are concerned about sex as a tool of oppression and also troubled by sexual repression, discrimination, and mass incarceration. Ultimately, I hope that complicating the progressive orthodoxies on sexual harm will promote more thoughtful policy choices. Policy choices about sex. Sex is a subject that conscripts us to knee-jerk punitive reactions. The book centers on a phenomenon I call sex exceptionalism. We can get a sense of what this is by asking a very simple question. Why is sex different? Why is sex crime different? It's simple because people from lay to learned hesitate little in answering, it's obviously different. It is such a simple question that nobody asks it. Instead, people instinctively believe that sexual assault is far worse than non-sexual assault, that sexual compliments harm more than non-sexual insults, and that sexual commerce is totally different from commerce. In criminal law, sex is ontologically fixed, particularly grave, and ripe for harsh punishment. Few question the presumption that adding sex to a criminal law equation wholly changes the stakes. No one stops to consider, why do I believe that molestation, which is often nonviolent and committed by children, is a magnitude worse than brutal but non-sexual child abuse? How come the presumption of family unification does not apply in the former? But we don't ask these questions. Why? Because sex is a great disruptor of reason. It has a hypnotic power that predisposes even sophisticated theoreticians to reflexive punitiveness. Few question what makes an activity sexual and a person a sexual threat rather than just a threat. But historians John D'Amelio and Estelle Friedman observe that, quote, sex is easily attached to other social concerns, and it often evokes highly irrational responses. Sex is a game changer, which is why narratives of sexual violation underlay a range of policy decisions, from educational programming to institutional design, border policies, and whether to go to war. Sex induces an acute analytic myopia that leads even thoughtful analysts to downplay or ignore the distributional, philosophical, and empirical frameworks they apply in non-sex cases. Of course, thoughtful scholars, feminists foremost among them, have offered various arguments for why sex crimes are, in fact, in a category by themselves. Still, many of these arguments, upon closer examination, are yet tethered to ancient notions about sex based in moralism and race and gendered constructions of dangerous sexuality. For example, many people accept that the law must punish sexual misconduct particularly severely because it uniquely devastates women. The notion of sex as female devastation has been around for millennia, stemming mostly from patriarchal, not feminist principles. Or consider the intuition that a person who commits a sexual transgression is a particularly evil or bad actor. So think of like a person who shoves another aside. And when I think of this, I always think of Trump shoving aside the prime minister of Montenegro. Well, think of that person, right? A person shoving somebody aside. That is not nearly as bad as someone who brushes up against another and derives sexual pleasure. The difference, experts say, is that the latter offends dignity. Yet this dignitary interest is left vague, lest it also invoke older ideas about deviance, race, and delicate feminine sensibilities. But the idea that rape law itself might be sexist and regressive seems completely implausible, partially because of a simple but potent folk history of rape law. In this telling, the historical problem was that woman protecting rape laws were under-enforced, riddled with exceptions, and rarely implemented because male society used random rape as its preferred technology of keeping women under control. This history underlies the widespread presumption that the emancipatory move is to ensure that rape laws cover as much conduct as possible, are enforced vigorously, and carry severe and therefore meaningful punishments. In this punishment-centric view, stronger sex crime enforcement not only reduces and deters violence, but it is also gender justice in itself. That the carceral position is the enlightened one reflects our impoverished understanding of rape's history and consequent overestimation of the criminal law's liberatory potential and underestimation of its costs. From the founding, sex crime law aimed to control, not liberate, women's sexuality, to confine sex to marriage, and to maintain racial and other hierarchies. Rape was a heinous capital crime, even warranting castration and burning at the stake for the right defendants, not because it harmed women or their equality, but because it deprived women, and more importantly, their husbands and fathers, of the woman's chastity and risked illegitimate children. Men could not be raped, and husbands could not commit rape. Rape, early lawmakers proclaimed, robbed women of, quote, what is most precious to them. So what was that? Today we might say bodily integrity, dignity, a sense of safety, but that was decidedly not it back then. Rape ruined women because their most precious commodity was virtue, right? What was virtue? Virtue was an aversion to free sex and sexuality. For this reason, unchaste women were categorically excluded from the victim category. But contrary to popular belief, this exclusion of a lot of women from the protection of rape law wasn't sexist leniency creeping into a victim protecting system. It was the system. The fallen woman was a consistent image in early American rape law, but in the mid-19th century, female virtue became an obsession. Under Victorian morality, the prostitute was the ultimate symbol of social degradation and defiance of marital and sexual morality, not to mention defiance of women's place as non-economic actors. The purity obsession coincided with a nascent feminism as elite women began to assert themselves into larger political and social conversations. For them, maintaining women's purity and marriageability and saving them from a life of ruin as a fallen woman was the goal. And it was a feminist goal, right? Non-marital and other indecent behavior, consensual or not, were equally ruinous. And feminists concentrated on stamping out vice, right? Unauthorized immoral sex in all its forms. Historian Jane Larson notes that the, quote, peculiar paradox of early feminist sexual politics is that mostly girls, not men, were placed in state custody to prevent underage sex. While Victorian morality ruled the entire Western world, there was a peculiar institution in America that really cemented the meaning of rape and rape law. Early slave codes and later Southern criminal codes reserved the harshest punishments like death, whipping, and castration for Black men. During Reconstruction, fomenting public outrage at bestial rapists and fear of black men destroying white Southern women's purity sustained lynching, the primary tool for maintaining de facto enslavement. But even anti-lynching advocates' hands were tied by the anti-rape argument. They too had to loudly and strongly condemn rapists of every color and vociferously defend the virtue of women. Thus constrained, capital punishment became activists' main argument against lynching. Within this discourse, the primary problem with lynching was not its brutality or even its racism, but its informality. Sexual monsters deserved death. Everyone agreed. But the state, not mobs, should administer it. Of course, this put the stamp of approval on legal lynchings, which at the time were no more than sham trial processes that produced summary public executions of black men. Lynchers responded to reformers with feminist-sounding arguments that formal trial processes would traumatize women. A pro-lynching newspaper explained that a woman who suffered a crime, quote, many times more brutal than death itself, should not be put on the stand in full view of a packed courtroom and then required to again look into the face and publicly proclaim her assassin. In 1870, the Klan rationalized its murder of Jordan Ware on the ground that, quote, the lady was spared the shame of appearing in court in a connection with a cause that the delicacy of any lady would shrink from in terror. The monstrous rapist image was always raced, and in the lynch era, cemented in the public's mind that rape is, quote, the Negro crime, as the National Police Gazette declared in 1905. Today, sexual assault continues to be condemned as the work of monstrous individuals. But few characterize the state and society-approved punishments of accused black rapists as sexual assaults themselves. But black lynching victims were stripped naked and castrated, their genitalia breathlessly passed around and kept by the white mob as souvenirs. The press described their beastly crime and sexual punishments in pornographic detail. Black men's sexual suffering and shame was a prime source of white solidarity for decades after Reconstruction. And today, much of society finds common ground in shaming, ostracizing, hating, caging, and inflicting harm on accused sex offenders. From the very beginning, the criminal system also punished wanted sex under fornication, sodomy, lewdness, and disorder laws. In the late 19th and 20th century, lewdness policing reflected a broad immorality of the poor paradigm, where sexual nonconformity, race, economic marginality defined deviance. The laws helped maintain the racist, sexist, and moralist sexual order, as well as the Industrial Revolution's economic order, by giving police broad authority to round up deviants, teens, unemployed workers, licentious women, freed people, labor organizers. As the nation moved into mid-century, preoccupation with male homosexuality put gay men not only at the mercy of these vagrancy laws, but also at the very center of sexual psychopath laws and the growing preoccupation with protecting children from predators. But then came the latter 20th century and liberal legalism. Liberal lawmakers reconceived sex crime law as protection against personal injury, not protection of marriage and morality, and they pushed to rename rape sexual assault. The 1962 Model Penal Code legalized adultery and fornication, extended rape to non-procreative penetration, and decriminalized sodomy. liberal feminists supported this project and urged society to view rape as, quote, ordinary criminal violence, instead of treating forced vaginal intercourse as the worst possible offense, which, one feminist noted, reflected, quote, ancient masculine norms. However, the model penal code's attempt to retrofit the rape system with an assault frame left much of the original structure. Penetration of a woman was still the highest offense. In defending this gender distinction, the modernist drafters couldn't say that, well, it's because rape robs women of virtue. So they threaded the needle by saying that women feel particularly harmed by sex. The drafters opined, quote, however devalued virginity has become for the modern woman, it is difficult to believe that its loss constitutes a comparable injury to the male. The modest retreat from sex exceptionalism was short-lived. In the 1980s, liberal feminists who supported the assault framework nonetheless worried that rape's existing force requirement and the decriminalization of deviance crimes created loopholes. So they lobbied to expand rape, which retained the penetration requirement of old and carried the high punishments of old. They lobbied for it to include non-consensual or even insufficiently authorized sex. Some even endorsed the idea that penetration itself was the problem. At the same time, a family values movement that was extremely powerful arose and blamed gays and feminists for the demise of morality. Remarkably, dominance feminists joined with them in the fight against prostitution and pornography. For these feminists, the law needed to control sex, not because of morality, but because sex was men's primary tool of oppressing women. These efforts ran into a national preoccupation over child sex predators, creating a sex crime criminal system that is exceptionally and virtually inalterably severe. But let me be clear. I am not saying that it is always thoughtlessly exceptionalist to treat, say, non-consensual sex as a more serious wrong than, say, an injurious, aggravated, but non-sexual assault. We yet live in a culture dictating that sex is freighted for women, and accordingly, it is possible that a female victim of sexual misconduct does feel more harmed, at least psychologically, than a male victim of even a severe beating. But this is just a possibility, not a universal truth. And it might be a sex exceptionalist, self-fulfilling prophecy. In any case, I am simply advocating that sex crime analysts take a beat before defaulting to instincts about sex's inherent gravity, instincts that may have been forged in the ancient crucibles of morality, patriarchy, and racism. In contemporary times, sex exceptionalism continues to serve as a profound legitimator of penality in this era of incarceration skepticism. In 2019, for example, New York officials announced a subway policing surge that met with strong objections from a liberal New York population wary of the racial implications of order maintenance policing. But then the governor invoked sex offenders, and liberals applauded the effort to combat, quote, subway sexual predators, as the New York Times claimed. Few voiced concerns that sex policing is also racist and devastating to unhoused people. But a recent study of lewdness enforcement found that unhoused LGBTQ youth are particularly vulnerable to arrest for urinating, changing clothes, and sexual intimacy. Similarly, few worried that, as in the immorality of the poor era, the public and police would define sexual threat by race. The surge occurred on the backdrop of a popular feminist anti-hassling movement that had gained a lot of traction during Me Too. In 2014, the anti-hassling group Hollaback released a video, which went viral, of a woman, an actress, subject to relentless catcalling while walking in New York City. In 10 hours of footage, all but one of the hasslers were men of color. Joyce Carol Oates drew fire on Twitter for stating the silent part out loud. Quote, "Would be very surprised if women walking alone were harassed in affluent Midtown NYC." One college student in a 2016 study put it this way, quote, "I think I'd maybe be less inclined to tell him to F off if he were more attractive. It's like a cultural thing that if someone that looks dirty is coming at you, people avoid them." There are these huge racial blind spots in this feminist hassling analysis. Susan Brownmiller, in her famous 1976 anti-rape book, curiously devoted several pages to arguing that Emmett Till's reported whistle really was a big deal, even empathizing with the murderer's anger that, quote, "this black boy had in mind to possess a white woman." Noting that she, quote, "came to understand the insult implicit in Emmett Till's whistle," Brownmiller recounts that thereafter, whenever a black teen hollered at her, she too, quote, "felt a fleeting but murderous rage." So in sum, I see this project as part of the fight against mass incarceration and anti-minority discrimination. The road to ending those are long, and we need to identify every obstacle along the way, whether it be persistent racism, punitive impulses, or neoliberal rationality. Sex exceptionalism is one such barrier, and I hope that confronting it facilitates new thinking and creative thinking about sexual harm. But less ambitiously, I just want to have the conversation. I'm mindful of Foucault's observation that, quote, "The effort to speak freely about sex and accept it in its reality is so alien to a historical sequence that has gone unbroken for 1,000 years now, and is so inimical to the intrinsic mechanisms of power that it is bound to make little headway for a long time before succeeding in its mission." So thank you very much.
We have plenty of time for some questions.
Heavy topic. Hard to get questions on the table, but you know, I'm an open book, so happy to answer. Making me nervous.
Perfect, thank you. Thank you. Hi, Professor Gruber. Thank you so much for that talk. It was, everything I could have expected and then more, so much more. And I'd like to ask you what you think about how a system will navigate the rise of LGBT youth of color. How will they navigate, or how do you see best to navigate such cases involving so many aspects of this sex exceptionalism that you spoke of? And thanks again.
Yeah, you know, it's funny because when I first started, and I have an article in the Stanford Law Review called Sex Exceptionalism in Criminal Law, which I'm now sort of expanding into a multi-chapter book. But when I started conceiving of that article, it was years before. And it was, it was before sort of the resurgence of straight, unbridled, unapologetic homophobia and anti-LGBTQ and anti-woman agenda on
Thank you so much. This sort of touches on something you were just talking about. I'm curious what you think about both the over-policing of LGBT youth in particular and the simultaneous under-policing, the sort of lack to justice and inequality in prisons and all of those problems. Is there some middle ground or
This
something?
goes to an article I'm writing on policing right now. This goes to my opinion of police work, which needs a whole other time. Over-policing and under-policing are kind of misnomers, right? Because over-policing is what the police do. And the thing we imagine that they're not doing, the under-policing part of it, like actually solving crimes, catching people, improving safety rates, that's really not ever been a huge function of the police. Clearance rates from the time there were organized police departments, about 25%, right? And even lower when you're talking about crimes that people care about. What do people care about? Burglary, theft, violent crime. What they don't care about, most of these disorder crimes, right? So I get it that I get the anti-defund the police movement, right? Because what we want is safety. What we want is a community that's not broken. But police mostly haven't put the resources to it. They put it towards street policing. High crime areas, slew of studies show that high crime areas are proxies for minority areas, or the fact that they interface with a minority. So, like if you ask a police officer if they interface with a black man, they're more likely to call the area that they're standing in at the moment a high crime neighborhood than if they simply interface with white people. Right? So all of these things are very racialized. And I think this is true of LGBTQ youth too, right? Because on the one hand, you know, not everybody seeks out the criminal law as part of their healing or justice process, but some do, right? Some do. Some want that experience. I think it's, you know, I have a lot of students and others come to me and say, well, here are my options, so here. And I just lay out the options in front of them. But sometimes they say, well, I want the police to hear me, right? Like, I want them to understand. And I say, well, good luck with that, right? And so, like, on the one hand, here they are out on the street doing lewdness policing that everybody thinks is great because, you know, the deviants are out there. And it's sweeping in trans sex workers, tons of trans sex workers, LGBTQ, unhoused youth. These are the most vulnerable populations to sexual abuse, state sexual abuse in the way they're patted down, the way they're shamed, and a host of other things. Studies also show that depolicing them, destigmatizing them, and sheltering them will stop that, you know, at least reduce some of that abuse, right? But we don't. We do that policing, that quote unquote over policing, that what I would call criminogenic, which means it causes crime, criminogenic policing, socially destructive policing. And at the same time, if you have an LGBTQ youth or a trans sex worker who was raped by a straight man, straight white man, you know, they might expect to get mistreated by the police, right? So you can think of these like, I don't get it. Like, why do we have over policing and under policing? Or you can think of it as, yeah, this is kind of part of it. We are putting our resources to managing populations that threaten elite interests. You know, whatever, in the Industrial Revolution, they called the migrant workers, like the hobos, right? And they would go from place to place trying to work. They would join strikes. They would join laborers. Those were the pictures of sexual deviants. They would sexualize them in ads and discourses. So, right, like, so there's this part of it where it's all managing, you know, populations that are unruly. And then there's a part of it of keeping us safe. And I don't think those two go along so well. I just don't. So that was more than you wanted, but that's what I think.
Oh, Professor Gruber, sorry. Before the next question, do you mind standing by the mic so the live stream can hear you better?
I'm so sorry.
No, you're totally
Yeah,
okay. Thank
I'm
you.
in my class. I want to get up close. Yes, I'll stand here.
In regards to racialization of rape and targeting certain groups on that. When you were talking, I couldn't help but think of the movie Birth of a Nation, which
It starts chapter 2.
Oh.
So maybe you want to say a little bit about Birth of a Nation, just if people aren't aware.
Oh, so just basically post-Reconstruction, about like, we're talking like 100 years ago, the Klan came out with a movie called Birth of the Nation, which basically speaks to what she was talking about, this whole white purity, virginity, and black people being like symbolized as like ape-like monsters trying to take them from the white man. But anyway, I was just curious if you saw if you're seeing anything else in pop culture that might be like like revitalizing that belief, or in
Well,
politics.
the Central Park Five was the birth of a nation of my, when I was, a teen, right? And and even though the Central Park Five, they've sued, they're now, spokespeople, and there have been movies about them. We still have the debate where we had one of the candidates saying that they confessed, saying that they killed a woman. I mean, there's still always that, right? So let me just add a couple of tidbits about Birth of a Nation. The reason why, I have some people say to me, like, look, if your critique of rape law is race, it's old hat. We've moved past that. I'm like, okay, well, first, we probably shouldn't move past that. But the reason I sort of hammer on race and rape is because I think that we have historians of Reconstruction, and we have historians of race, and we have historians of sex, right? And we have historians of rape. To me, these histories cannot be separated. It was not chance that white supremacists in the South, to maintain the regime of, white supremacy and enslavement-like conditions after the Civil War, it doesn't surprise me that they chose rape, right? Because rape had for so long been mired in just this national identity of being a moral Christian nation and our women being delicate. Rape narratives were deployed during the Revolution, that the British military were going to come over with their, dirty soldiers and sully American women, that it, I think, more than murder, certainly more than murder of men. Maybe if they'd chosen murder of children, although back then, in the late 19th century, children weren't the sort of objects of fascination and sympathy that they are now. So I don't think any crime could have justified lynching the way that rape did. And mostly the lynchings weren't for rape, but it didn't matter, right? Invoking this narrative, and I have quotes in my book where they say this, allowed people to say, one white woman, a suffragist and a feminist, said, even if something like he was castrated, his eyes were plucked out by pinchers, and he was dragged in the streets, and torn limb from limb, I even think she said, that wouldn't even come close to the suffering of a woman whose virtue was destroyed. And so, that's powerful. It really, narratives of rape played a real role in sustaining lynching, and played a huge role in American national reconciliation after the Civil War, because when you think of when Birth of a Nation came, it was 40 years after. It was in 1915, right? It was racist. I mean, it shows, well, it was all about, again, rape, right? It was black men. It was the uppity black men who the Reconstruction politicians allowed to come in, and he was going to, and it had ignorant, former enslaved people stuffed ballot box for. He was going to marry a white woman, and then it was the other former soldier who was pursuing a woman through the woods, and she jumps to her death, right? They castrate. They lynched that soldier, and the censors had to cut the castration scene. But it's a really highly, highly racist movie. At the end, they the Klan rides in to save the day, and then they show Jesus over like frolicking white people, literally. So, it's a spectacle to see. It was the first major motion picture of the motion picture era, and it busted box offices. I mean, it was the orchestra, live orchestra. And when they showed it in good northern theaters to people who were slavery abolitionists, they cheered. They cheered, right? So not only was this race connection so instrumental to the reign of terror in the South after the Civil War, it was instrumental in forging a national identity, right? Bringing back together American national identity, right? Cohered, glued together by whiteness through looking at the bestial black man as a rapist. And that is just true. I mean, that is just what the history of this crime, of this narrative is. That, we always think of a liberatory crime narrative. So it was a great question, and I happened to know the answer.
Thank you.
I saw you earlier. Hi, Professor Gruber. Thank you for coming to talk to us today. Earlier this year, Professor Dressler was here and gave a similar talk around sex crimes. And he kind of mentioned a concern about a kind of pendulum regarding either too much kind of progressive kind of like criminalization of sex crimes could then lead to it turning the other way. And I was curious about your thoughts on that, if you agreed with him, if you have a different perspective, or could just speak to that in general.
Well, I think, first of all, sex crimes, the way they're not exceptional is a lot of their trajectory, at least in the, sort of 80s and 90s, was consistent with other sort of tough on crime trajectories in the criminal law, the 3 strikes laws, banning parole, just making sentences like carjacking sentences. And this is a phenomenon that's been studied a lot of time, and we may be going through that kind of phenomenon again with there being, such heightened crime fears, which are very interesting because crime rates have precipitously declined in this last year, like a lot. And so I'm not, it's kind of a new thing. I have some theories, but they're not tested as to why sort of the crime mentality is rising. But what happens is you have an offense like carjacking, right? So carjacking was always punished, pretty highly, like 10, 5, 10, 15 years. And then you had in the 90s, like a bunch of newspaper articles about carjacking, and then, politicians got to get in on it and say, we're going to get tough on carjacking. Well, you can add 20 more, years to carjacking, and but there never was either a carjacking spike, nor did tacking 20 years on to 10 years do anything, right? If even the 10 years did anything, given that 25% of these crimes are solved, right? Like, so in that way, there's been a lot of that. Where I think sex is different is, these sex registration, notification, sort of these like laws that just make you a banished pariah in society in ways that, okay, even quote unquote felons, because they were, the worst, right? Like when I was in law school, like a felon. Now, we have felony registry. People kind of understand that felonies encompass a range of crimes. So even the felon has been rehabilitated. The super predator has been put to rest. The sex predator, that's still, more and more calls for punitivity. Louisiana just authorized physical castration for child sex offenders, right? So we're back there. And so to me, this is more than tough on crime, right? It goes on the backdrop of this highly, gendered and raced history, this sort of like uber punitive sentiments. And so my whole thing is this, I can't profess to know for every crime or even for this crime where the optimum criminal law lies. But just like any decision, right? Like if you make a decision and it all turns out good, you're like, that was a great decision, right? And you might have just done it on the fly without thinking, and it turns out to be a great decision, or you can think through a decision, think a million times, make the decision, it turns out terrible, right? I mean, you can't really know 100% of the time, but you can theorize how we arrive at decisions. And to me, if we're arriving at decisions about how to reduce harm, help survivors, prevent sexual victimization, and yes, do some accountability, but you're arriving through it in this emotional impulse that comes on the background of years of millennia of cultural conditioning, you're probably not making as good of a decision than if I can get you out of that mindset. And so that's kind of where I'm at. And I do think that it has gone towards overly punitive. We have the harshest system in the world. I mean, we're bringing back castration, right? So it's, where do you go from there, right? Like, we've been so punitive. And I also think a problem with it is when we have this sort of built-up feeling about sex crimes and sex offenders, it's also used to justify the harshness of the entire system, which, again, I mean, we incarcerate people. I mean, like like Europeans are like, what are you doing? Incarcerating all your, and it's expensive. People could say, well, what if your daughter was raped, right? There are rapists out there, there are rapists coming across the border. They're right? So this dialogue, right, this sense we have of sex crimes, I think whatever you think good policy is precludes the conditions of making good policy.
Hi, Professor Gruber. My name is Tay. I've been following the kind of the horrific French woman Giselle's case, and I kind of wanted to see what your thoughts are on that and what the impact would be after the trial, even for the French who seemingly feels more like progressive about sex than Americans, and how that.
I think it's great, and I think that it's great when a survivor can come up, be empowered by the process, and serve as a symbol to other people who've been harmed. You're not ruined, right? You shouldn't be ashamed. The person who did it to you should be ashamed. You should speak up, and you should seek the redress you need to seek. You should try to change the policies that you believe to need to be changed. I think all that is great. But I say when, because we have this idea that's what criminalization does. And I have a lot of survivors come to me, and there are studies on this too, and especially when it's interfamilial and there's love still and connections there, that say, I don't like what happened to me, but I don't necessarily want this person to have, if not life in prison, then social death, right? Through the registries and things like that. And I don't want to have to portray myself on the stand as a ruined, good, traumatized victim in order to get the conviction, right? And so I think it depends on the person. I've spoken to victims who, they just want help not navigating the process. They go in, eyes open, they know what it's about, and they're like, I just want to try it. Okay, that's fine. But most of the time, it doesn't go that way. And what we do know is all of this pretty much isn't doing anything to deter, right? It isn't giving services to people, and it's certainly not addressing populations that are particularly vulnerable to sexual abuse. And I'll say the final thing. Maybe this isn't true of French trials or this particular French trial, but in American trials, studies have showed that victims do need to portray devastation, starting from the very beginning. They have to portray a quote-unquote rape-consistent story, right? And in fact, police and prosecutors will sometimes lead them into one, right? Where they just, they said no a million times. They had no, behavior that might be considered consensual behavior, that they're utterly devastated, that they told everybody they knew, right? So I am not sure that, in fact, I'm pretty sure not, that gender justice, destigmatization, empowerment, prevention, and all that good stuff comes through the criminal legal system. Even if this one high-profile case is really good, right? Just like sort of everybody coming out and saying Me Too and I'm not ashamed is really good. The carceral stuff doesn't ever distribute that way. Where does it distribute? To the usual policed subjects. For example, statutory rape laws, right? There was a big push in the 1990s, and it still exists today, that enforcing statutory rape laws was going to be funded under the theory that it was going to reduce welfare payments. So they would go into poor Black neighborhoods and find the teen girls who were pregnant and do some statutory rape prosecutions, sometimes of both of the teens, right? So again, we've got to understand not just kind of how these laws are made, which I think it can be problematic, but also how they distribute. And that is great. But as a lawmaker, how many of those happen for everything else that happens?
Yeah, do you mind closing us out?
Oh, yeah. So here we are. It's 6 o'clock, actually after 6, and we promised that you would be done then. And we actually have a bag of swag that the dean was supposed to give you. But you also got the orange socks. I asked her to wear it with her red slacks, and she said no. She was a fashion plate. But I think you proved me right. What a wonderful speaker.
Thanks again for having me at the Centennial celebration.
Yeah, absolutely. Good. Thanks.
Great.
So,
I just want to say thank you for the talk. I remember we read a lot of your articles in Dressler's Casebook, and